back, everyone. It's time to start talking about some labor and employment issues. Joining us today is Robert Bernstein, partner in Lehner Muchin in the Chicago office. Robert focuses his practice on employment and traditional labor matters and disputes, as well as collective bargaining and negotiations on behalf of management. He's a longtime member of the Advisory Council and presenter for the Illinois Restaurant Association, and he participates and engages regularly with the Illinois Hotel and Lodging Association. Ladies and gentlemen, please welcome Robert Bernstein.
Thanks so much, Steve. I appreciate it. It's great to be here today. I love this conference. I can't wait till we could do everything in person again, but this will do for now. What a year, or a little over a year it's been. What a crazy world we're living in, and hopefully for the restaurant and hospitality world and everyone else, we're moving in a positive direction out of this pandemic sooner rather than later. But in the meantime, as a labor and employment lawyer representing a lot of restaurants and hotels and other employers, what we've seen during this time is an increase in the amount of employment-related claims and litigation as it relates to events and occurrences that have emanated from the pandemic. And if we could go to the next slide, please. There's been a couple different types of categories of cases that we've seen and that have been filed against, restaurants, hotels, other employers. And the first type is cases that are based on alleged violations of COVID-related employee protection. So for example, what do I mean by that? Well, there was the Families First Coronavirus Response Act, or I'm going to call it the FFCRA today, to abbreviate it. But that law went into effect on April 1 last year. It expired December 31 last year. I'll come back to that later. But it basically provided emergency paid sick leave and or expanded FMLA leave for different COVID-related reasons. And to the extent that employees were disgruntled and thought that their rights were violated under the FFCRA, well, they could raise those issues. The other types of categories of cases that are based on traditional employment laws, but that have some nexus to the COVID pandemic. And what do I mean by that? Well, your race and national origin type claims, your age discrimination type claims, your Americans with Disabilities Act type claims, your pregnancy type claims, claims against those classes of individuals that have seemed to be more potentially susceptible to having issues in the COVID pandemic domain with their, whether it be with their health or their age, making them more susceptible to contracting COVID. But those are the types of cases that I'm talking about there. And those type of cases would typically, by and large, be filed with the EEOC or some other state counterpart agency. The other piece to the second category of cases, which we're going to talk about, is retaliation cases. And they have been a big area where people are alleging that they have been retaliated against by their employers for a whole host of complaints related to the workplace, whether it be that the company, isn't adequately protecting its employees in terms of its safety measures, and they complain and then they get terminated or disciplined. Well, there's all different permutations to these types of retaliation claims, but that's what I mean there. Let's go to the next slide, please. So when we look at the statistics, okay, and these are ever evolving, but in summary fashion, since the onset of the pandemic in February and March 2020, there have been over 1,000 COVID-related employment lawsuits filed throughout the country. Of the complaints that have been filed nationwide, approximately 50% have alleged retaliation, whether that's based on complaints regarding workplace safety, for exercising protected COVID rights under the FFCRA. The other most common types of COVID-related employment claims are those alleging violations of worker safety. I want to pause there. There's going to be a slide later on OSHA, the federal agency responsible for investigating and rectifying issues pertaining to safe workplaces. And there has been a deluge of claims with OSHA throughout the country. And I think that under the Biden administration, okay, which is a separate point here in terms of a moving target and the evolving nature of things to watch, I think across agencies, whether or not it's OSHA, whether or not it's the Department of Labor, whether or not it's the EEOC, I think by and large, and it's going to take some time, but I think we're going to see a more pro-employee, pro-union bend to these agencies than we did under the Trump administration. So stay tuned as to that, but that's going to make it all the more important that employers pay attention to these issues, because if they become embroiled in these type of claims before agencies, perhaps before some courts, they are going to be doing so with more peril perhaps than they were under the prior administration. Okay, but alleged violations of leave of absence laws like the FFCRA or the FMLA, and as I mentioned, discrimination type claims, where we've seen also a number of claims in this discrimination area, is where as a result of the pandemic, employers, I don't need to say it, but particularly in the hospitality industry a lot of times, but other industries as well, have had to lay a lot of people off or furlough a lot of people. And as a result of those personnel actions, we've seen a host of discrimination type claims crop up. Next slide, please. So let's talk about retaliation and whistleblower type claims for a few minutes. Well, these generally assert an employee was terminated or otherwise retaliated against for complaining about an employer's lack of adherence to COVID-related safety protocols, such as if there's a failure by the failure to enforce social distancing requirements and potentially exercising their rights under the FFCRA, FMLA, or other leave statutes. Next slide, please. I put a couple cases on this slide. One of them is against a pizza place. Take a read of these. They're both, one of them, they're not both. One's out of New Jersey and one's out of state court in California, but just wanted to give you some interesting cases where there were retaliation and whistleblower type issues. Next slide, please. I mentioned age discrimination. We're going to be seeing more and more of these sort of claims. And the thought here is that there's a growing concern over the treatment of older workers in the workplace due to the general perception that older adults age 60 plus are more susceptible to COVID-19. So these claims could arise in a number of ways, but I've had for a number of my clients during this time frame situations where elderly employees are asking for some form of an accommodation, whether it be a leave of absence, an extended leave of absence sometimes, whether it be to work from home, whatever it is, employers have been faced with making decisions as to whether or not they are willing to do that, whether or not they can do that from a business standpoint. And if they take more drastic actions in the face of these requests in terms of denials or terminations of elderly individuals, well, it could lead to more age discrimination claims. And again, I've given a couple samples from the federal court in New York on this slide of different age discrimination type claims. Next slide, please. In the race, national origin, and ancestry area, that's another hotbed here before the EEOC. And the EEOC has said that they've noted an increase in complaints of discriminatory animus based on race, national origin, and ancestry by workers of Asian descent or who are perceived to be of Asian descent, okay? And the one thing I have here is the third bullet point. Please, on the employer side, if you're going to engage in layoffs, furloughs, recalls, make sure that you're vetting those things through human resources, through your employment law counsel, to make sure that you're not stepping into any landmines in terms of your selection process. Make sure that if you become embroiled before the EEOC or a court, that you have a good, legitimate, non-discriminatory story to tell to support your personnel actions. Next slide. Pregnancy discrimination, I mentioned, is another one. The danger that employers may treat pregnant employees differently due to their beliefs about the susceptibility to COVID-19. I've had a number of instances where we've had pregnant employees at different clients, and the pregnant employees have either asked for some form of an accommodation, or where the employer felt uncomfortable about having the pregnant employee do certain tasks, even though the pregnant employee didn't say anything and didn't feel that there was any issue. Both of those scenarios have to be navigated very carefully to make sure that you're not stepping into, a pregnancy discrimination claim, or you're not taking unnecessary risk in this area. And then caregiver status is one of the reasons under the FFCRA that you can get protection. And these sort of claims have come up where, as in this example, in this Eastern Airlines case in Pennsylvania, the airlines denied the employee's request for FFCRA leave, and it led to a claim here. Next slide, please. Well, one of the biggest areas that I've had, just from a counseling standpoint on behalf of my clients, the company's hospitality clients, you name it, is ADA claims. And they come in a couple different forms. They come in the form of requests for reasonable accommodation in the COVID pandemic setting, requests to work from home, requests to work modified schedules, requests that they need some form of extended leave. Whatever it might be, employers have been faced with some difficult decisions in this time frame, and it's led, the decisions, depending on what they are, have led to different pieces of litigation throughout the country, different charges of discrimination before the EEOC and state counterpart agencies. The other area where I've had ADA issues is, where actions have been taken, termination actions or disciplinary actions, and where individuals have alleged that due to their disability or medical condition, the employer relied upon that and not some legitimate non-discriminatory reason in taking the action. Next slide, please. Why don't we skip this, because I had mentioned the failure to accommodate, and we can certainly get into that in the deeper dive. This is an area I really want to hit on more. Wrongful discharge claims, that relates to potential claims by terminated employees where they're alleging that their employer had improper reasons to fire them, such as for refusing to violate a stay-at-home order or for requesting FFCRA leave. I should put an asterisk here. So for those of you that are wondering what the status of the FFCRA is, well, it expired December 31, 2020. It was not extended. However, a couple things to note. As of now, employers can electively, if the employee at issue did not already take the emergency paid sick leave at issue, okay, they can allow the employee to take that through March 31, 2021. Still needs to be supported by the documentation, and it's got to fall within the ambit of one of the 6 qualifying reasons for FFCRA leave. But they can get a dollar for dollar tax credit through March 31 of 2021. Stay tuned though, because you guys have probably seen that Biden is already looking at some form of a paid leave program and may expand the FFCRA type leave further. So we're watching very closely, and there may be some changes in the imminent future. So, what I just said, may be definitely susceptible to change, and let's all pay attention to that. Next slide, please. Tort claims, a myriad of different tort claims. These fall typically in the camp of where an employer is alleged to not have taken the appropriate precautions or to have allowed employees to work in an environment where they weren't really caring for the employees as well as they should have, or they failed to warn employees of other potential COVID cases. So it could take a variety of different forms, but we've seen these, and I think we're going to see more as as some worse things happen in this area in terms of employees getting COVID going forward. Next slides. The public nuisance doctrine, this is an interesting one, but this is one where the allegation is that the employer's action have created a public nuisance that will further spread COVID-19. And the goal of these claims is not damages for injury, but it's to protect society from harm via injunctive relief, forcing the employer to comply with applicable safety laws or guidance. In the big case, one of the big cases that have come out recently is in May of 2020, a case like this was brought against McDonald's in Illinois. And please take a read of that, but it's an interesting, fact scenario there. And, we'll see, if we get more and more of these types of theories brought, the public nuisance doctrine. Next slide, please. And then these are some more examples of tort claims. Take a read of these. Walmart was sued for a wrongful death type of claim as a result of an employee who died of COVID. And then the last thing I want to mention, and we'll save the rest for a much deeper discussion in our roundtable next week, which I'm very much looking forward to. But next slide, please. There's the potential for workers' compensation claims as a result of people contracting COVID in the workplace. You do have to show a nexus between, what the atmosphere or environment was at the workplace and how you contracted it. Keep in mind that different states have different standards and different laws in this area. So it's going to be dependent also on what state you're operating your business in. But this is another area where we will see and can see an advent of more claims in light of the pandemic. So thank you very much, everyone. As I mentioned, I love being part of this conference, and Stephen and his team do a great job, and great to be with you. And like I said, I look forward to next Wednesday. The one thing I'll end with is, in light of the potential for all these claims emanating from the pandemic, please make sure that you're working with human resources, your labor and employment counsel, to do a variety of protective and preventative type of things and measures that you can take to make sure you're insulating your business as much as possible through, making sure your handbook is up to date, in terms of COVID related policies and protections, making sure that your COVID related safety measures are in line with what the government agencies would want. All these sort of protective, preventative measures to best mitigate risk in this area in light of the uptick in the number of employment-related litigation claims that we've seen as a result of the pandemic. Thanks very much.
Hey, thanks, Robert. That was great. Thanks for those tips at the end, and also for making us aware of those items and bringing them to our attention so we can plan to prevent accordingly. We'll definitely be looking forward to your deeper dive. So thank you. And everybody, thank you, and we'll see you next time. Bye for now.